They hid stuff. They changed the documents. They altered the documents, and they did it on purpose. I'll get to the Ashley Merchant rule in a second, but as I pointed out in the letter yesterday, Your Honor, 915.14 is our abusive litigation statute in the civil world. This is a civil action. There's no, I couldn't find any guidance in the case law surrounding the Open Records Act that defined what substantial justification for their failure to comply, what that actually means. So I had to go digging in the abusive litigation statute, and that statute specifically defines substantial justification as lacked substantial justification as meaning substantially frivolous, substantially groundless, or substantially vexatious. Well, frivolous and groundless both can be satisfied by the plaintiffs, by us, by showing that they lacked a legal basis for their arguments. And we've demonstrated that they have not raised any legal basis for their arguments. So we win on both frivolous and groundless under the statute just by showing they didn't assert a legal basis in their defense. Groundless also could include a factual basis, an excuse, if you will, for why they didn't comply. That is where I think Your Honor has some questions to resolve regarding Mr. Bond's testimony. You, of course, with no jury, you're the trier of fact.
Sorry, Mr. Merchant. Let me interrupt you for a second. So, first of all, let me just ground us again for a moment, because it is a non-jury trial, because I am the trier of fact, because, you know, we're forcing procedural pit stops along the way that don't come naturally when it's just a bunch of lawyers in here talking. But technically, what you are talking about right now is a response to Ms. Alavi on behalf of the two defendants' motion for directed verdict. And I understand you need to address each of those elements, but it sounds like you're starting to stray into argument about why you think you should win, as opposed to just argument about why I should direct a verdict against you.
And I was doing that, Your Honor, because
okay.
I was sitting there thinking to myself, well, am I going to do a closing separately from this with no jury, or am I just going to go up there and talk?
I mean, if you feel like it's all the same thing, I'm okay with that. I just want to make sure that we sort of know where we are.
You're the trier of credibility. I think you sat here and you listened to him. We all did. And I think you can understand that our position is he is the personification of the failures in this case. He's the personification of the failures in this case because he specifically testified that he has an Ashley Merchant rule. And the Ashley Merchant rule, which is contrary to his #1 rule, means that he doesn't pick up the phone for her, and that he digs in, and he's defensive, and he's obstructionist. The way he testified is exactly how they responded to the open records request. He didn't assume that there was a valid purpose or a legal purpose and then go try to help Ms. Merchant find these things. He did the opposite of that on purpose. He did this because he linked it himself specifically to the timing. And we heard from Ms. Alabi too about this today. He, on the stand, linked it to the timing of the criminal case and the motion that Ms. Merchant filed in that case in January of this year. That's when the wheels fell off, because he wasn't listening. He wasn't trying to comply with the law. He was trying to find a way to parse her requests. He must have said it 4 or 5 times, garbage in, garbage out. So that's his excuse for failing to comply, because he decided, I'm going to determine that's garbage in so I can give garbage out. And he did that on purpose because he was not going to communicate with her. So the excuses he gave, and I think this is something fairly that Your Honor needs to consider, is the credibility of the excuses he gave. Because frankly, under the statute and under the interpretation of the definition of substantial justification, you've got to find, frankly, that you believed him. Not only did you believe him, but that you believed that they were substantially justified in relying on these excuses for failing to comply for some 9 to 10 months. Even in the face of a lawsuit where he I'll get to in a second, claimed he never read, and then said he believed it to be frivolous. So the cyber attack, he claimed at some point that part of the reason they couldn't comply was the cyber attack. That only applied for a very short amount of time. It certainly is understandable that they would have difficulty responding, at least electronically, to certain things because of the attack. We're not questioning that. But what happened when it was over? They didn't go back and start to redo it and fix it. They didn't do anything like that. And not only that, on the stand, he didn't even attempt to link up the cyber attack with any actual delay. He just said in general terms that they had a cyber attack. He didn't say in this specific case how it prevented him from responding to Ms. Merchant appropriately or timely under the law. Excuse number 2. The January 9, 2024 request was not elevated to him. This appeared to be, from my view, someone trying to throw an employee under the bus. That because it wasn't elevated to me, I was not aware of it. We know that's not true. At the time that he testified to that, he was not aware that Ms. Merchant had an email from September of 2023 with he and Erica Willingham on it, showing very specifically that he had talked about critical mention and that they had actually prepared these documents in the prior year. But he told Your Honor under oath that he had no idea what critical mention was in January of 2024. We know that's not true. When he got caught with his hand in the cookie jar, he tried to pivot around it and then finally had to concede, well, yeah, I did deal with that. That's my name. His name on the email was Dexter Q. Bond. He also told you that he didn't know who Dexter Q. Bond was when Ms. Merchant showed him the forfeiture documents with his name on it. It's just incredible. So he's with regard to the failure to elevate, this is, if it's anything, it's a failure to train the employees properly. Let's assume that he didn't have a nefarious reason for testifying the way he did, and that he was actually telling the truth that wasn't elevated to him. Well, it cannot be the plaintiff's burden. It cannot be the citizens of Georgia's burden to train employees who are dedicated and responsible for responding to Open Records requests. It's just not, that can't be a function and it can't be a defense to justify not timely complying with the law. More importantly, Your Honor, if that excuse held any water, it certainly lost all the water by January 26th because we know he wrote a letter to Ms. Merchant outlining all of the issues. So to the extent it wasn't elevated prior to January 26th, we know Dexter Bond was involved going forward starting on January 26th. So what in the world justifies the period after January 26th through September and even now when we still don't have some of the documents? Excuse number 3, Mr. Bond assumed the first matter was resolved because Ms. Merchant didn't specifically follow up. And when she was on the stand today, I heard questioning about this as well. Did you follow up on every single little thing? And I think Your Honor even asked Mr. Bond, what happens if you say no responsive documents? Is it the plaintiff's burden or the citizen's burden to ask, are you really sure about that? You know, that's not what the law contemplates. The Open Records Act certainly doesn't contemplate us having to cross-examine the agency's responders. We can't do that, and we can't do that for one very important reason, which Ms. Merchant pointed out today. We have no idea how they keep their documents. We don't know who the custodians are. We don't know whether they're stored electronically. We don't know if, in this case, there's an IT department that has superior control over electronic information. We have no knowledge of that. You'd have to be somewhat sophisticated across the board to figure out how different agencies store their documents to be in a position to cross-examine, or, in his words, follow up about things that we may not even know about. I think the 44 pages is very instructive, Your Honor. He was very cagey about that, and he was cagey for a reason. They altered the documents. There's no other way to put it. And
to give the benefit of the doubt, I think it may still be problematic because even if the court doesn't assume that it was intended to obfuscate anything, the holder of the record can't have it both ways and say, I'm not required to create a document that does not exist in order to respond to you, but then in responding to you, create a document. That those two things can't coexist. I'm not as willing as you are to assume that it was intentionally done to obfuscate, but it is still problematic.
Right, and exactly, Your Honor, because I think, you know, he hemmed and hawed about that considerably when Ms. Merchant was questioning him about this, and he could have easily just said on the stand, yeah, that was a compilation that she put together and she took stuff out. He could have said that, but he spent 15 to 20 minutes arguing with her about whether it was a compilation or whether information was actually missing from the document initially. And then finally he conceded, yeah, there's stuff missing. And then he, as an open records officer, we asked him specifically, you know, what's your obligation under the Open Records Act to produce a copy, a true copy of the document? And he wouldn't answer it. He said for some reason he just didn't know. And then eventually he conceded, well, yes, I do have to produce copies. But my larger point, Your Honor, I think is the way he testified is very important, because I think it establishes the mental mindset they had when he responded to these requests. And so I think the reason why that's important, I know Your Honor doesn't want to get into the machinations of the intent, and I totally understand that. But the reason why it's important is because it colors his testimony about these excuses. Because if he can't even tell the court in candor why that document is not an original document and won't concede it's an original document, that's the thing. That's the personification of this problem and why we're here today. So the final excuse that I noted was they were just too busy to comply. That's not a defense to an open records request. It's just not. It's certainly not a defense to an open records lawsuit. They have to find a way to operate within the confines of the law. There's no exception in the statute that says I get a pass because I'm a larger county, I'm a larger agency, I have more employees, or I have more requests. That doesn't carry the day. So that argument falls flat, Your Honor. So, and I'll save the linkage to the legal standard for later, but I think based, and I'll be candid with the court, there's been talk of why we didn't call all these witnesses. We subpoenaed everybody under the sun. We called blah, blah. We intended to call those folks. First, they filed motions to quash everybody. They did not want us to talk to those folks, or did not think we needed to as an initial matter. But two, once Mr. Bond took the stand, I looked at Ms. Merchant and said, I don't think we need anybody else. I think he has just made our case for us because of how he's testified. So that's why we didn't bring a laundry list of folks in here, because it was unnecessary. I think the court has plenty, based on his own testimony, to find that we have overcome a directed verdict. Well, on a final point, Your Honor, before we get into the issues in closing, is this issue of vexatious. Just briefly, and I think if we go back to the number one thing he kept saying, he said, I'm not going to reach out and talk to you. Communication has been taken out. When he does that, and he does it only for Ms. Merchant, he's designed the process to make it more harassing, to make it more annoying, to make it impossible without further follow-up and constant follow-up by Ms. Merchant to get the issue resolved as it's supposed to be, more informally. He forced our hand. There's no doubt about that. We would not be here and we would not have filed a lawsuit had he just picked up the phone and tried in good faith to comply. So the standard is whether or not that's designed to be harassing and annoying. And I think if you looked at his testimony when he was responding to Ms. Merchant's questions, I don't think a single soul listening to him could disagree that he was trying to be harassing and annoying to Ms. Merchant while on the stand, and he actually made it very personal. And I think the fact that he took it very personal and that it was very much a Ashley Merchant issue is what colored the responses by his agency and by him. I think this, and we've seen it today with Ms. Alabi coming in here and arguing things that just aren't relevant at all to the legal inquiry. And the reason for that is they have marching orders. Whether they're appropriate or not in the context of open records is not our fight. It honestly isn't. It's, did they give us the documents when they were supposed to? Do they have an excuse for not giving us the documents when they were supposed to? And if they have an excuse, is it justified under the law? And we think we've shown through Mr. Bond and through the evidence that we more than satisfy directed verdicts. We'd ask Your Honor to deny the motion. And on just a separate issue, because I don't think it was addressed, we got this motion, as I mentioned, just before Your Honor took the bench, and it asked you, Honor, to sanction us. I'm not going to cross that bridge because you're not crossing that bridge yet. But I also think that that's important for understanding why they have attempted to put up a smokescreen and just avoid the real issue here, which is, did they comply with the statute? They will do everything under the sun to divert Your Honor's attention. I know you're smart enough to not let that work, but that's what they're doing. They're just throwing up a smokescreen, hoping that you'll be so overwhelmed with the idea that we might actually ask for documents related to a criminal case that you're going to be blinded to the real issue here, which is, did they comply under the law? And we think that they did not.
Thank you. So, Ms. Alabi, it's technically your DV motion. If you'd like a brief rebuttal. Just briefly, Your Honor. Into the microphone, and if you will state and spell your name for the court reporter.
Ashley Merchant. My first name is ASHLEIGH. My last name is Merchant, MERCHANT.
Go ahead.
Thank you, Your Honor. Good afternoon, Ms. Merchant. How are you?
Oh, I'm good. How are you?
Good. And to clarify, you are plaintiff or one of the plaintiffs in this case, is that correct?
Yes.
Okay. And this case was filed on January 30th, 2024, correct?
I'd have to defer to my husband on that. That sounds about right. January.
Okay.
I know it's late January.
Okay. But if it's in the record as January 30th, you wouldn't argue with that?
I have no reason to dispute that.
Okay. And since we were last together at the hearing a few weeks ago, have you received any additional documentation regarding any of the requests at issue here?
Yes, we received some more NDAs.
Okay. And with respect to those NDAs that you've now received, do you believe that new documentation includes that particular request regarding the NDAs?
No, I don't.
Okay. And what is the basis of your belief that that is not complete?
Yeah, so I've talked with several people who were employed by the district attorney's office that have signed NDAs. People have reached out to me, prior investigators, prior lawyers have reached out to me and said that they signed an NDA and they wanted to talk to me about certain things, but that they had signed NDAs and they wanted to take a look at the NDAs to see if they could talk to me, and I didn't have their NDAs. They weren't part of the group that you gave me. So, and those witnesses didn't have copies either. They said those were copies that had been left at the DA's office. So I know 4 or 5 people I've talked to had signed NDAs, and I don't have those. So that's why I believe I didn't get all the NDAs.
Okay. And were those people current or former employees of the district attorney?
Former. I think they were all, yeah, they were all former.
Okay. And did they relate to you that those NDAs were signed during the time period encapsulated by that request?
Yes. And some of them had actually reached out to me, which is why I originally requested it. So a witness would reach out to me and say, hey, I really want to talk to you about something that went on, but I'm worried about this NDA. I don't know what the punishment is for the NDA. And so that's why I first knew about the NDAs. You know, a witness would say, I really want to chat with you, but I don't know if I can be sued under these NDAs. And I didn't know what was in the NDA. And I told him, obviously, I can't give you legal advice, but I should at least be able to see the NDA because I believe, based on the one that I had from Mr. Wade, that the only punishment was that they would be fired if they spoke with anybody. But you know, that's why I originally asked for the NDAs. I was surprised that a public agency had required something like that to be signed.
Okay. So previously we've discussed just generally open records requests made by you or your office to the county. Would you say that you frequently make open records requests to either the county or the district attorney's office?
No, I actually would not say I frequently did. I was surprised Mr. Bonds testified that I had made 40-something. I've made, I believe it's 10 to the district attorney. I mean, total maybe, I don't know, less than 20 in total to Fulton County entirely. All of the different entities. I made, I believe, 10 to the DAs, right around 10. A couple of the ones that I made to other groups, like I made a request just, for example, to IT or purchasing, and then Dexter Bond went in and closed it out from the DA's office. So I actually didn't make an open records request to the DA's office, but somehow in your portal he went in and was able to close it out. And so the open records request in the portal would show closed, and it would have a letter from Dexter Bond attached to it saying closed, see this letter, which I hadn't even made the request to the DA.
And so Of those approximately 10 requests that you've made, what's the time frame over which you've made those requests? Do you know?
A year.
So in the last year. Okay. Now, when you make those in the past, have you ever had occasion to need to follow up because you felt like you didn't get what you were looking for?
Yes.
Was that only with the DA's office or other entities?
It was primarily with the DA's office.
Okay. And when you've done that in the past, have you ever, how have you handled that previously?
So out of the open records request, I think the easiest thing is to sort of classify ones that related to criminal cases that were pending and then ones that didn't. The ones that are subject to this lawsuit really are ones that relate to no criminal case. I had a criminal case that I was doing open records where I was seeking invoices and contracts for an independent contractor who was working on that particular case. So I did a series of open records requests to try and find the contracts that were the contractual authority for that person to be hired, how that person was paid, whether or not they had an oath of office, things like that. So those were things I was investigating in regards to that criminal case. Most of those requests were some were partially filled, let's put it that way, but they were not completely filled. I did have a hearing in that criminal case, and I was able to use my subpoena power to get records in that case. That is why those records were not subject to this lawsuit, ultimately. They might have been initially subject to this lawsuit, but ultimately they were not something that was sought because I was able to get those through subpoena. The issue is I can only subpoena things that are relevant to a hearing that I have and the issues in that hearing. So I did open records. Let me just kind of back up. I did open records, and then I got a hearing. When I got that hearing, I was able to issue subpoenas for those same things that I had been denied in open records. I was able to get them because I could issue a subpoena in that hearing. I could not, however, issue a subpoena for things that weren't relevant to that hearing, which is why this open records lawsuit has continued.
What would you say that those things that have been requested pursuant to the requests in this lawsuit are related to the ones in the other criminal case as well?
No.
They're not in the same line of inquiry? All right, I'll move on a little bit here to the subpoenas that were issued during the course of this litigation.
Yes.
Were those all sent to employees of the district attorney's office, or were they sent to people from different entities as well?
There were multiple different places that I sent them. So I had subpoenas to third-party vendors. I subpoenaed Critical Mention, which, for example, had I not subpoenaed them, I would have never known about, because I still haven't to this day received copies of the payments for the second year of the contract. Critical Mention was a 2-year contract. The first 12 months was paid through purchasing. So I received the county documents from purchasing about that, showing I had the contract and I had the actual payment. The second year I asked and asked and asked, and I've never received it once from the county, still to this day. I received it from Critical Mention. So I did that.
Were there others besides Critical Mention, individuals that were employed in other agencies or other certain, at least, departments of the county?
Yes, there were other departments of the county. So I sent them to Critical Mention. I sent to IT. I sent to, I think one of the ladies used to work for Fani Willis, and now she works for a different department. I sent it to them too.
So when you're subpoenaing individuals who do not work for the district attorney with respect to documents that you believe are in the possession of the district attorney's office, how are those individuals supposed to know if the district attorney has those items? And do you believe, I guess let me start with that question first.
Which question?
How do you believe, or why do you believe that those individuals who are not a part of the district attorney's office would have access to or possession of requested documentation that you requested from the district attorney's office?
Well, they did actually have it. That's how I got most of it. So I don't know how. So that's the problem.
They had possession of district attorney materials?
Yeah, IT did. That's where I got all the emails from. So IT apparently did. And you have to understand, when I don't work for Fulton County. So when I do an open records request, I don't know how their systems work. I don't know how things are stored. I don't know things like that. So I know that there are documents. I know that there is for example, there is a PowerPoint attached to an email that has its only DA employees on that email. I know that PowerPoint exists. Do I know how the county stores it? No. And I have learned that I have to ask for it every different way way I can possibly ask for it in order to avoid someone saying no records exist. So I asked for it from the DA's office. They did not give it to me. I asked for it from IT. IT, all of a sudden, is able to access all of those. So apparently IT can go into the DA's emails. I did not know that, but I'm glad I subpoenaed them because I learned it.
Did you believe any of the individuals who do not work for the DA's office, at this point we'll say other than IT because you've explained that, but any of the individuals who don't work for the DA could produce documents on behalf of the district attorney responsive to your request?
I don't know. You'd have to ask me. You'd have to be more specific who you're talking about.
Was there anybody that you subpoenaed that you believe could produce documents on behalf of the district attorney's office other than individuals who work for the district attorney's office?
Okay, I think I understand what you're asking. So I didn't care if they were produced on behalf of the district attorney's office. I just wanted the documents. So when I've just, for example, subpoenaed ITs, obviously they're not producing them on behalf of the DA. They're producing them on behalf of IT. I really don't care who produces them. I just wanted the documents. So yeah, Critical Mention supplied documents. They were not supplied on behalf of the DA, but they were DA documents.
Do you believe that just because somebody who has dealt with the DA's office has documents, that those documents are also held or belong to the district attorney's office?
I'm sorry, I don't understand what you're asking me.
If Critical Mention is producing documents, how can you be sure that those documents are also in the possession of the district attorney's office?
Because the law requires that the district attorney comply with the Records Retention Act. And so, for example, to answer your question, Critical Mention was paid with a check out of the district attorney's fund. It says, the check says DA Willis for Fulton County. The law requires the DA's office maintain copies of all of that. And so I would assume that when I asked for that document, since the law requires that they maintain that document, that they would provide it to me.
Have you filed, in this case, are there any claims in this case regarding record retention, or is it just open records?
So an Open Records Act litigation is not going to involve a violation of the Records Retention Act. But when I'm asking for a document in Open Records, one of the things that I want to know is, does the document exist? Does it have to exist? Because I've learned one of the answers that I get, particularly from the DA's office in Fulton County, is no responsive records. So I have to go look at the records retention because they say no responsive records. Well, they've taken a position that we don't maintain any records, essentially, so we don't have to give you anything. But the law actually does say that they have to maintain certain records. So I go and look at that. I'm not going to ask for something that I don't know that they're required to keep.
Is that a position that they've taken that's been taken in this case, that the district attorney isn't required to? I'll withdraw that question. But based on the response, I want to go back a little bit to your understanding of, do you agree that the DA's office and the county themselves are separate entities?
Yes.
Okay. And so even if a different department has documentation, that doesn't mean that the district attorney's office necessarily has that documentation. Would you agree with that?
Depending on the documentation, yes.
Yeah. And so even if the people who you subpoenaed in this case that work for other departments had that documentation, it doesn't necessarily mean that the district attorney's office has that documentation.
In this case, it did, because when I subpoenaed those entities from the district attorney, I also received the same set of documents. So clearly they did have it.
Okay. Now, with respect to
right now seems to be going towards the intent that the plaintiffs had in seeking the records, or the use to which they intended to put those records. And I'm not aware of that being a relevant factor for the court's consideration. If that is, then please tell me why I should be considering that. But my understanding is essentially, is it a public record, and was it properly requested in a way that was understandable and could have been complied with?
And Your Honor, I think maybe this goes more towards less the actual production of the documents and more towards the attorney's fees issue. So I will withdraw. I'll hold off on some of these questions until we get to the attorney's fees portion.
Thank you. I appreciate that, Mr. Bowman.
All right. If you give me just a minute, Your Honor, let me make sure that that's exhausted my questions on the substantive portion. A couple points that I would like to go back to regarding the documentation that you did end up receiving from IT related to emails. Because you've named the district attorney's office and the district attorney's office is who's still at issue in this case, if they did not have those documents, you said you received them from IT, correct?
I received them from, well, I received them from you. So you all, actually Ms. Monroe, I received them from Ms. Monroe. They did not send them to me directly. Ms. Monroe sent them to me. She sent them to me from IT, Fani Willis, Dexter Bond, Kevin Armstrong, I'm trying to remember everybody. There were 4 or 5 different people. She sent them to me as the certified records in response to our subpoenas for all of those folks. And there was someone else, maybe Jeremy Murray.
And was that certification of those records, do you know, did that come from the district attorney's office or from the IT department?
It came from, so whoever, Ms. Monroe, it came from Ms. Monroe, but she sent it, like, if it was the IT packet, it came from IT. Like, whoever was in charge of IT certified that. They did the business record certificate.
And being that if IT is the entity that provided those documents, would you agree that that's not relevant to what the DA had in their office if they are documents that the IT department has?
Well, they're the same documents that you provided me from the DA's office also. So you provided them to me from Fani Willis, Dexter Bond, Kevin Armstrong, all of those people. So I basically, it was like 197 pages and I got the exact same set of documents. I don't know where you all got them from. You could have gotten them from IT, you could have gotten them from the DA. I have no idea where you got them from. But I was, the same set was certified from each different agency or each different person, but it was one set of documents. I have no idea where you guys got them from.
Okay. All right. And Your Honor, could we have just a moment?
Sure.
All right, thank you. Just one or two more follow-ups. I apologize. With respect to the NDAs you believe are still outstanding and the individuals you spoke with, do you know, or could you provide the names of those individuals or the individuals that you believe have NDAs that are still outstanding? And if you can't recite it now, to be able to provide it to us?
I'm, like I told you before, I'm happy to provide it to you, but the witnesses that told me that don't want the district attorney to know who they are. So, I mean, if the court wants me to provide it, that's fine. I'm not hiding it at all, but those people have asked me not to. They don't want the district attorney to know that, so.
I guess at this point, though, if we would ask for them, because if they're at issue in the case, we would need to know who they are so that we can check if those documents actually exist.
Right. And those are the people that have told me that they signed NDAs, which you all did not provide me the NDAs. So they're the only ones I know. But, I mean, you provided 122, and there's a lot of DAs that aren't in there. So I don't know if they were pick and choose. I mean, who signs NDAs, who doesn't? I have no idea.
Right. Right, so just if we can have those. And then I think the rest of the questions I had, we'll save for the rest of for the attorney's fees portion.
So the names of those individuals, to my way of thinking, would be relevant to two issues. Number one is whether or not their NDAs have been provided for purposes of any injunctive relief that the plaintiffs are seeking. I don't think that their names need to be disclosed in open court for that purpose. The second reason that it might be relevant would be the extent to which there's any way to identify or understand if the fact that those 4 or 5, persons' NDAs were not produced is somehow indicative of a failure to produce others that might be in the possession of the DA's office. I also am not sure, particularly given that they're former employees, if that would be relevant in open court either. But if you feel strongly, I could be persuaded, Mr. Bowman.
No, Your Honor, we're happy to take them off the record so that we're not putting people's names out in open court. That's fine, just so we can confirm whether or not those documents do exist.
Okay, thank you.
I'm happy to provide them.
Thank you. With that, I believe that's all I have for this portion. We'll come back to a few more questions.
Okay, understanding that you're reserving your right to question her on other matters.
Yes, thank you, Your Honor.
Mr. Merchant, questions for this witness?
No further questions for this witness on this issue, Judge. While she's on the stand, though, if Your Honor's inclined, I can question her about damages now, or we can wait for Your Honor's ruling on the liability issues. But we don't have any additional evidence but for damages.
Okay. I think that just for efficiency's sake, it would just make the most sense to go ahead and have you question Ms. Merchant regarding the issue of damages and outstanding issues, if there's any injunctive relief other than the NDAs.
And yes, Your Honor, I think the issues with injunctive relief, to tackle that issue first, I think the ones that we set forth in the email to you, those are still the current issues, okay, and framed in that manner as well. I'm not aware of anything else. Ms. Merchant has testified, obviously, to some things that she thinks probably are incomplete and has evidence of that. But as we sit here today, there's no way for us to tell you how to tell them to do it.
Okay.
Which I know puts you in a tough spot.
As an aside, the Supreme Court has said that one of its forthcoming opinions tomorrow will be the Gonzalez versus Miller case.
Of course. May I approach?
Yes, sir.
Mr. Merchant, I've handed you a copy of pre-marked plaintiff's exhibit number 24. Can you recognize it?
Yes, this is my record of time, description of work performed. It's a Word document that I kept with an outline of my time that I had to spend on this litigation.
Okay, is this a true and accurate copy of the time record that you prepared in the case?
Yes.
Are all the time entries listed on this document for the civil action case number 24CV001325?
Yes, and the open records that before the action number came about.
Okay, can you tell the court how you prepared this document?
Yeah, I just keep keep track as I'm going. Keep an open Word document. I really was trained. I used to do work for the 11th Circuit Court of Appeals as an appointed lawyer, and this is how they like them to be done. They like their times kept like this. I used to have a judge who appointed me fun cases, and so I had to learn how to keep my time for that. And so we keep them in increments, time increments, 0.10 tenth of an hour increments, and so it's just tracking what I did on the case.
Okay, what is, before I ask you that, Your Honor, at this time, plaintiff would move into evidence plaintiff's exhibit number 24.
Mr. Bowman?
No objection, Your Honor.
Exhibit 24 is admitted.
Ms. Merchant, can you tell the court the total number of fees and hours that you had in this case prior to today?
So this document is as of September 30th. I had 78 hours, 78.7 hours, and then attorney's fees. So attorney's fees, you know, to be fair to the county, it definitely significantly reduced my normal average rate and looked more towards what the Attorney General pays for this type of litigation. And so my total attorney's fees as of September 30th were $23,610.
Okay, can you tell the court how you arrived at the $300 figure based on your review of the Attorney General's website?
Yes, so I went to the Attorney General's website. There's a couple entities that hire outside counsel to do work in civil cases, and one of them is the Attorney General. They publish every single year. They publish, they're very transparent with their rates that they pay lawyers, and they're very transparent with how much money these lawyers bill. So they actually publish it online. You don't even have to do an open records request. You can just go online and click it, and it shows it. And so I reviewed all of those, and lawyers that have been practicing approximately the same amount of time that I've been practicing, I used those rates.
How would your private rate for your services be different if you had not used the Attorney General's website?
Oh, it would be far higher than $300 an hour. I mean, I've been practicing 21 years and, you know, do highly specialized work. I mean, I would charge at least $600 an hour.
Government approach?
Yes.
Sergeant, I'm showing you what I previously marked as plaintiff's exhibit 29. You recognize it?
Yes.
Mr. Merchant, I can't hear you.
He showed me what is marked as plaintiff's exhibit 29. It is an affidavit that I prepared that has a very brief outline of my my past work and. Yeah, sorry.
Is it a true and accurate copy of the affidavit you yourself prepared?
Yes, it is.
Okay, Your Honor, at this time, plaintiff will move into evidence. Plaintiff's exhibit number 29.
29?
Yes.
Any objection?
No, Your Honor.
Exhibit 29 is admitted. And did you say it's like a CV or a?
Affidavit.
Okay, an affidavit, thank you.
So, Ms. Merchant, can you explain to the court a little bit more about your experience as a lawyer?
Sure. So I went to the University of Florida, Levin College of Law. I graduated in 2003. I came to Atlanta and I worked at the Southern Center for Human Rights. I actually did some civil litigation with them, and I did death penalty defense work in Georgia and Alabama. Prior to coming to Atlanta, I worked for a criminal defense lawyer in Florida. And then when I moved to Atlanta, I worked at the Southern Center. When I was admitted to the bar here, I was sworn in June of 2004 in this courthouse. Judge Baxter swore me in, and I worked at the Metro Conflict Defender at the time. That was prior to the Indigent Defense Act, so the Metro Conflict Defender actually had the contract for state court work. So I was a public defender downstairs in state court here, and then I left that job to take a job at the Office of the Public Defender, which had the felony contract. So I moved to do felonies, and I was in the complex trial division at the public defender here when it was Vernon Pitts, and then I moved to the appellate division. And then I left that, I had my first daughter, and left the public defender to open my own law firm. I first opened it, I had two. I had one in Buckhead, and I was in office with some other lawyers, and then I had an office in Cobb County. And I have been, since 2008, I've been in private practice. 95%, I would say, is criminal defense litigation. 5% is civil. It's usually things like this where I have to get involved somehow, or my expertise as a criminal litigator somehow comes in handy.
So can you tell the court a little bit about whether you've been recognized in your field of practice?
Yes, I have. I've received a number of honors. I am the current, like I mentioned earlier, I'm the current president of the Georgia Association of Criminal Defense Lawyers, which is kind of a long track. So I've been on the executive board for 5 years. I've been a super lawyer for over a decade. I'm old enough to be super lawyer, not rising star. But before I was 40, I was rising star. I have received on the Rise Award from the daily report, received a year ago an honor from the Southern Center for Human Rights with you about our work in a civil action case that we had, a very large plaintiff's case, doing public interest type work, but have definitely received the Cobb Bar Award for Champion of Justice, received Gachtel's Award for Champion of Justice, so I've been very blessed.
And the work you performed in this case, can you explain to the court how you and I divided up the labor in the case?
Oh, yeah, that's easy. I do the facts. So John does all the civil stuff, and I do mostly the facts. So anytime there were like a factual basis that needed to be written, that would be my job, determining all the facts and keeping records of all the facts and keeping all the documents clear. The actual, the legal drafting we would do together to a certain extent, but you would do the primary legal drafting, and then I would just assist in it.
Your Honor, may I approach?
Yes.
Merchant, I'm handing you what I previously marked as plaintiff's exhibit number 23. Do you recognize it?
Yes.
Mr. Merchant, I can't hear you when you're walking back to this podium.
I asked her, I'm handing you what I previously marked as plaintiff's exhibit number 23. Do you recognize it? And she said yes.
Yes.
What is it?
This is our expenses. The first couple pages are input into a program we use called Clio, and then it's all receipts from all of our expenses in this case.
Is it a true and accurate copy of our expense report for this case?
Yes.
Your Honor, at this time, plaintiff would move into evidence plaintiff's exhibit number 23.
Mr. Bowman?
No objection, Your Honor.
Exhibit 23 is admitted.
Can you tell the court what our total expenses in this case are prior to today?
$1,339.23.
And to be clear, are you the one that put the entries in the document?
No, my paralegal did.
Have we had discussions with Ms. Bergdorf about that?
Yes, we have.
And you're clear from that document that these all relate to this particular case?
Yes, I am.
Ms. Merchant, when you sent all of the requests, whether it be to the county, to the DA's office, in any shape or form, did you do so in good faith?
Yes.
Okay. And when you and I filed this complaint, did you do so in good faith?
Yes.
That's all I have, Your Honor.
Okay, thank you. Mr. Bowman?
Thank you very much, Your Honor. All right, Ms. Merchant. So when in this case, who is your attorney in this case?
John and myself. I mean, I'm an attorney, so, it's myself and John. We're a small firm.
So you are representing yourselves effectively.
Yes, I'm, one of them, but John does the majority of the litigation in civil cases.
And then a little bit of an odd question to ask given circumstances, but do you have an engagement agreement with the firm regarding this case?
I don't think so, but John would know.
Your Honor, we'll stipulate that we did not hire
I was going to say, I don't think so.
Okay. With that said, was there anything other than what you already discussed about how you determined the rate that would be applied for your services in this case?
Like, why a certain rate?
Yeah, how did you settle on the $300 figure?
Because it's a public agency, because this is the county. I mean, it's reasonable for the county. I mean, I don't currently, but historically, I've done plenty of appointed work, and I always have a reduced rate for that. Like, I do it for the federal government, for the 11th Circuit, and it's always at a reduced rate, so.
So essentially your rate for government work?
Definitely.
Now, has anybody, other than you and Mr. Merchant, has anybody else been reviewing the time spent in this case to determine the reasonable amount of time?
Reviewing our time, is that what you asked?
Yes.
No.
Okay. Is there anyone else working to control the costs or direct the litigation in this matter?
No.
Okay. Did the potential back up. We've seen a number of orders entered in the case regarding cameras in the courtroom and media related to this case. Have you coordinated with any media entity at all regarding this case or the hearings in this case?
I haven't coordinated. I will say that if someone calls me, my policy is always if someone calls me and asks me for a document that's a public record that's already on file with the clerk, if some news agency calls and asks me for something, if it's already a public record, I have no problem sharing that.
Have you reached out directly to any media organization or reporter or other individual to proactively reach out to them to discuss this case?
That I've initiated the contact?
Yes, ma'am.
I wouldn't say I've initiated any. I mean, there are reporters that I talk to that I'm friends with that have asked me about the status, but I don't think the one I'm thinking of, I don't actually think has ever reported on this case.
Is there any other, without revealing the substance of any such conversation, have you discussed this case with any other attorney, other counsel on the criminal matter that's related to some of the issues here?
There's more than one criminal matter, I think, that could be related. I have told some of the other lawyers about the status of this case, if that's what you're asking.
Okay, have you discussed any strategy with any other counsel?
No, not strategy.
Okay. Anything about the factual underpinnings of the case with the other counsel?
The facts of the case, I have definitely, I mean, John and I are lawyers, like we talk to lawyers, so yeah, I definitely have talked to other lawyers about the facts of the case.
Okay, are any of those lawyers representing co-defendants in the case in which you represent Mr. Roman?
I have told lawyers in the Roman case about some of the facts in regards to open records.
And again, without revealing any attorney-client substance, have you spoken with Mr. Roman about this case?
Yeah, but not really at any great length. Well, because this case, so when you talk about this case...
Hold on.
Well, yeah, let me interject here for a moment. Let me say this. I understand certainly that part of the DA's position, the defendants, the district attorney's office, and Madam DA in her official capacity, is that perhaps these requests were not substantially justified because they were intended for use in the prosecution of Michael Roman, right? I absolutely understand that. I don't know that it's an efficient use of our time to sort of beat that horse, because I certainly understand that that's the position of the DA's office.
And Your Honor, the reason that I bring it up is, number one, counsel opened the door with discussion about good faith and the good faith activity in the case. I think it goes a little bit to good faith when we're talking about the level of publicity that somewhat this case, but certainly the other case, have generated, and the interest in the goings-on at the DA's office in particular, and as well as the sort of some of the expansion and all the subpoenas, specifically including the subpoena to Madam DA herself in this case. I do think it goes to the reasonableness of that, and then therefore the reasonableness of the attorney's fees.
Okay, fair enough. Mr. Merchant, your response?
Yeah, I didn't know.
Mr. Merchant, if you could sit down and be on the mic. Thank you.
I'm a slow learner. My wife can tell you that. Well, I didn't open the door to attorney-client waiver. And he specifically asked her, what did you talk to Mr. Roman about? She is his counsel in a separate case, so he cannot inquire as to communication she had with her own client, even if it's marginally relevant, which I don't think that it is.
Well, there are a number of privileges that would attach in terms of attorney-client work product, et cetera. I mean, I think the point's been made. And to the extent you wish to inquire further, I'm not saying you can't. I'm just letting you know, I get your point about that aspect.
And I just note, Your Honor, I didn't ask about specific conversations, just whether she had spoken with Mr. Roman.
Fair enough. Go ahead.
With that said, I'll continue on. Has there been anybody else outside of you and the members of your firm, Mr. Merchant, who have provided any input or funding at all into this case?
No, haven't gotten a dime.
Okay. Do you have any agreements or discussions with any outside parties regarding anything that regarding the proceedings in this case?
No.
Okay. Has any of the work in this case been billed to clients in Mr. Roman's case?
No.
Has any of the documentation that you've received in this case been utilized in that case?
No. In this litigation, no.
In the subject of this litigation?
Right. I want to make sure you weren't saying in response to any open records.
No.
Because
no.
early on, so when we filed it, just to qualify, just to make sure that it's perfectly clear, when we filed this litigation in January, there were a number of outstanding open records requests that were also part of this litigation originally. I was able to subpoena those documents when I had a hearing in the Roman case, and some of those specifically were things like invoices, things like that. So I asked for those under open records. I didn't get all those. So they were initially part of this litigation. But then when I got a hearing date in the Roman matter, I was able to subpoena those, and so I was actually able to get those so they didn't have to stay part of this open records.
Thank you. I do want to go back to Exhibit 24 in this case, which was the description of the work performed. Mm-hmm. Now, we talked about this case having been filed in late January of 2024, and I'm looking at page 1 of Plaintiff's Exhibit 24, and I'm seeing entries that begin in September, going up through onto page 2, going to all the way up through prior to filing the complaint in this case. Is it your contention that the correspondence and the issues that were dealt with prior to the filing of this case is something that should be included in attorney's fees?
Yes, because it was all part of what I had to do to get responses to the open records. If you look at page 1, and you know what you're referencing on the second page, page 2, so how it's supposed to work is I'm supposed to file an open records, ask for the document, and then you all give me the document. When it doesn't happen that way and I have to follow up and email and beg and plead and explain again and again for months, that's all part of what is leading up to the litigation. And that's what you'll see on the first page. Follow up on email, follow up on ORA response, send another email. And you actually, okay, so to answer, I'm glad this is in front of me now. I can qualify my answer earlier. The complaint to the Attorney General was in October, October 17th. So I filed this lawsuit in January. I mean, these issues were still outstanding. So clearly the Attorney General complaint wasn't going to fix things. But no, all of these are part of pre-suit, I guess, work is what you could talk about. And let's just be clear, if they'd been complied with over this 6 months, there would never have been a litigation. But like November 29th, send an email following up with the county regarding
I haven't asked you a question at this point, so I appreciate that. But, if you could give me just 1 second, Your Honor, just to make sure that I've hit everything. Double check. That's all I have at this point, Your Honor. I would reserve it just in case there's any redirect.
Thank you, Mr. Bowen. Mr. Merchant?
Yes, I just have one question for you. So, Ms. Merchant, we had to hire outside counsel, and they had to read all the correspondence that you had sent to the county and to the DA's office, and got up to speed, done all the legal research and all of that, and we paid them their rate. Would it have been more expensive for us to do that, or less expensive than handling ourselves?
Way more expensive, cost prohibitive.
That's all I have, Madam.
Okay, I have a couple of questions just to make sure I know what the exhibits are that I'm looking at. I heard Exhibit 23 being identified as a document supporting claimed expenses of $1,339.23.
That's correct, Your Honor.
Okay. And then separately, Exhibit 24, which some questions, I mean, I've seen that it is a table with individual entries of time. What I was less clear on is this as to all time expended by the Merchant Law Firm, or is it just as to Ashley Merchant?
This is my time.
Okay.
This is my time.
Okay. Thank you.
And then do you want them?
Yes, please.
Thanks.
Thank you. Anything, was that the only question you had? Anything else, Mr. Bowman?
No, Your Honor.
Okay. Ms. Merchant?
No. Okay.
Yeah, that was all I had. You may be excused.
Thanks.
Drop your comments below and let's discuss. Don't forget to like, subscribe, and hit that notification bell to stay in the loop with all things justice. Thanks for tuning in to Black Justice Media. Remember, your voice matters in this fight for justice. Catch you next time, Church. Drop your comments.